We back at chapter 5 of leases of immovable property. 105, lease defined. A lease of immovable property is a transfer of a right to enjoy such property made for a certain time, express or implied, or in perpetuity, in consideration for a price paid or promised, or of money, a share of crop, service, or anything or any other thing of value to be rendered periodically or on specified occasions to the transfer to the transferor by the transferee who accepts the transfer on such terms. Leaser, leasee, premium, and rent defined. The transferor is called the leaseor, the transferee is called the leasee, the price is called the premium, and the money, share, service, and other thing to be so rendered is called the rent. (106) Duration of certain leases is in absence of written contract or local usage. 1. In the absence of a contract or local law or usage to the contrary, a lease of immovable property for agricultural or manufacturing purposes shall be deemed to be a lease from year to year, terminable on the part of either leaseor or leasee by 6 months' notice, and a lease of immovable property for any other purpose shall be deemed to be a lease from month to month, terminable on the part of either leaseor or leasee by 15 days' notice. 2. Notwithstanding anything contained in any other law for the time being enforced, the period mentioned in subsection 1 shall commence from the date of receipt of notice. 3. A notice under subsection 1 shall not be deemed to be invalid merely because the period mentioned therein falls short of the period specified under that subsection, where a suit or proceeding is filed after the expiry of the period mentioned in that subsection. 4. Every notice under subsection 1 must be in writing, signed by or on behalf of the person giving it, and either be sent by post to the party who is intended to be bound by it, or be rendered or delivered personally to such party, or to one of his family or servants at his residence, or if such tender or delivery is not practicable, affixed to a conspicuous part of the property. 107. Leases how made. A lease of immovable property from year to year or for any term exceeding 1 year or reserving a yearly rent can be made only by a registered instrument. All other leases of immovable property may be made either by a registered instrument or by oral agreement accompanied by delivery of possession. Where a lease of immovable property is made by a registered instrument, such instrument, or where there are more instruments than one, each such instrument shall be excluded by both the leaseor and the leasee, provided that the state government may from time to time by notification in the official gazette direct the leases of immovable property other than leases from year to year or for any term exceeding 1 year or reserving a yearly rent, or any class of such leases may be made by unregistered instrument or by oral agreement without delivery of possession. 108. Rights and liabilities of leaseor and leasee. In the absence of a contract or local usage to the contrary, the leaseor and the lessee of a movable property as against one another respectively possess the rights and are subject to the liabilities mentioned in the rules next follow, or such of them as are applicable to the property leased. A. Rights and liabilities of the leaseor. A. The leaseor is bound to disclose to the leasee any material defect in the property with reference to its intended use, of which the former is and the latter is not aware, and which the latter could not with ordinary care discover. B. The leaseor is bound on the lessee's request to put him in possession of the property. C. The leaseor shall be deemed to contract with the lessee that if the latter pays the rent reserved by the lease and performs the contracts binding on the lessee, he may hold the property during the time limited by the lease without interruption. The benefit of such contract shall be annexed to and go with the lessee's interest as such, and may be enforced by every person in whom that interest is for the whole or any part thereof from time to time vested. B. Rights and liabilities of the lessee. D. If during the continuance of the lease any accession is made to the property, such accession, subject to the law relating to alluvion, for the time being enforced, shall be deemed to be comprised in the lease. E. If by fire, tempest, or flood, or violence of an army or of a mob, or other irresistible force, any material part of the property by wholly destroyed or rendered substantially and permanently unfit for the purpose of which it was let, or let the lease shall, at the option of the lessee, be void. Permanently unfit for the purposes for which it was let, the lease shall, at the option of the lessee, be void, provided that if the injury be occasioned by the wrongful act or default of the lessee, he shall not be entitled to avail himself of the benefit of this provision. F. If the leaseor neglects to make within a reasonable time after notice any repairs which he is bound to make to the property, the lessee may make the same himself and deduct the expense of such repairs with interest from the rent, and otherwise recover it from the leaseor. G. If the leaseor neglects to make any payment which he is bound to make, and which, if not made by him, is recoverable from the lessee or against the property, the lessee may make such payment himself and deduct it with interest from the rent, and otherwise recover it from the leaseor. H. The lessee may, even after the termination of the lease, remove at any time whilst he is in possession of the property leased, but not afterwards, all things which he has attached to the earth, provided he leaves the property in the state in which he received it. I. When a lease of uncertain duration determines by any means except the fault of the lessee, he or his legal representative is entitled to all the crops, plants, and sown by the lessee and growing upon the property when the lease determines, and to free ingress and egress to gather and carry them. J. The leasee may transfer absolutely or by way of mortgage or sublease the whole or any part of his interest in the property, and any transferee of such interest or part may again transfer it. The leasee shall not, by reason only of such transfer, cease to be subject to any of the liabilities attached to the lease. Nothing in this clause shall be deemed to authorize a tenant having an untransferable right of occupancy, the former of an estate in respect of which default has been made in paying revenue, or the leasee of an estate under the management of a court of wards, to assign his interest as such tenant, former, or leasee. K. The leasee is bound to disclose to the leaseor any fact as to the nature or extent of the interest which the leasee is about to take, of which the leasee is and the leaseor is not aware of, which material increases the value of such interest. L. The leasee is bound to pay or tender at the proper time and place the premium or rent to the leaseor or his agent in his behalf. M. The leasee is bound to keep, and on the termination of the lease, to restore the property in as good condition as it was at the time when he was put in possession, subject only to the charges caused by reasonable wear and tear or irresistible force, and to allow the leaseor and his agents at all reasonable times during the term to enter upon the property and inspect the condition thereof, and give or leave notice of any defect in such condition, and when such defect has been caused by any act or default on the part of the leasee, his servants, or agents, he is bound to make it good within 3 months after such notice has been given or left. N. If the leasee becomes aware of any proceeding to recover the property or any part thereof, or of any encroachment made upon, or any interference with the leaseur's right concerning such property, he is bound to give with reasonable diligence notice thereof to the leaseor. O. The leasee may use the property and its products, if any, as a person of ordinary prudence would use them if they were his own, but he must not use or permit another to use the property for a purpose other than that for which it was leased, or fell, or sell timber, pull down or damage buildings belonging to the leaseor, or work mines or quarries not open when the lease was granted, or commit any other act which is destructive or permanently injurious thereto. P. He must not, without the leaseur's consent, correct on the property any permanent structure except for agricultural purposes. Q. On the determination of the leasee is bound to put the leaser in possession of the property. 109. Right of leaser's transfer. E. If the leaser transfers the property leased, or any part thereof, or any part of his interest therein, the transferee, in the absence of a contract to the contrary, shall possess all the rights, and if the leasee so elects, be subject to all the liabilities of the leaser as to the property and part transferred, so long as he is the owner of it. But the leaser shall not, by reason only of such transfer, cease to be subject to any of the liabilities imposed upon him by the lease, unless the leasee elects to treat the transferee as a person liable to him. provided that the transferee is not entitled to arrears of rent due before the transfer, and that if the lessee, not having reason to believe that such transfer has been made, pays rent to the lessor, the lessee shall not be liable to pay such rent over again to the transferee. The lessor and the transferee and the lessee may determine what proportion of the premium or rent reserved by the lease is payable in respect of the part so transferred, and in case they disagree, such determination may be made by any court having jurisdiction to entertain a suit for the possession of the property leased. 110. Exclusion of day on which term commences, where the time limited by a lease of immovable property is expressed as commencing from a particular day. In computing that time, such day shall be excluded. Where no day of commencement is named, the time so limited begins from the making of the lease. Duration of lease for a year. Where the time so limited is a year or a number of years, in the absence of an express agreement to the contrary, the lease shall last during the whole anniversary of the day from which such time commences. Option to determine lease, where the time so limited is expressed to be terminable before its expiration, and the lease omits to mention at whose option it is so terminable. The leasee and not the leaseor shall have such option. 111. Determination of lease. A lease of immovable property determines A, by effects of time limited thereby, where such time is limited conditionally on the happening of some event by the happening of such event. A legal definition of efflux. Medical terms, efflux is the process in which bacteria transport compounds outside the cell, which are potentially toxic, such as drugs or chemicals or compounds. It says effluxion of time is the expiration of a lease term due to a natural passing of time rather than from a specific action or event. This phrase can also be used to indicate the conclusion or expiration of an agreement in simple writing when the conclusion or expiration occurs through the natural cause of events. It also says efflux in Black Law Dictionary. The running of a prescribed period of time to its end. Expiration of lapse of time, particular applied to the termination of a lease by the expiration of time. So, C, where the interest of the leaser in the property terminates on or his power to dispose of the same extent only to the happening of any event by the happening of such event. D, in case the interests of the lessee and the leaseor in the whole of the property becomes vested at the same time in one person in the same right. E, by express surrender That is to say, in case the leasee yields up his interest under the lease to the lessor by mutual agreement between them. F, by implied surrender. G, by forfeiture. That is to say, 1, in case the lessee breaks an express condition which provides that on breach thereof the lessor may re-enter, or 2, in case the lessee renounces his character as such by setting up a title in the third person or by claiming title in himself, or 3, the lessee is adjudicated and insolvent and the lease provides that the lessor may re-enter on the happening of such event, and in any of these cases the lessor or his transferee gives notice in writing to the lessee of his intention to determine the lease. H, on the expiration of a notice of determine the lease, or to quit, or of intention to quit the property lease duly given by one party to the other. Illustration to clause F. A lessee accepts from his lessor a new lease of the property lease to take effect during the continuance of the existing lease. This is an implied surrender of the former lease, and such lease determines thereupon. 112, waiver of forfeiture. A forfeiture under section 111, clause G, is waived by acceptance of rent which has become due since the forfeiture, or by distress of such rent for such rent, or by any other act on the part of the lessor showing an intention to treat the lease as subsisting, provided that the lessor is aware that the forfeiture has been incurred, provided also that where rent is accepted after the institution of a suit to eject the lessee on the ground of forfeiture, such acceptance is not a waiver. 113, waiver of notice to quit. A notice given under section 111, clause H, is waived with the express or implied consent of the person to whom it is given by any act on the part of the person given it showing an intention to treat the lease as subsisting. Illustrations. A, the lessor gives B, the leasee, notice to quit the property lease. The notice expires, B tenders, and A accepts. Rent which has become due in respect of the property since the expiration of the notice is waived. B, A, the lessor gives B, the leasee, notice to quit the property lease. The notice expires and B remains in possession. A gives to B as lessee a second notice to quit. The first notice was waived. 114, relief against forfeiture for non-payment of rent. Where the lease of immovable property has determined by forfeiture for non-payment of rent, and the lessor sues to eject the lessee, if at the hearing of the suit the lessee pays or tenders to the lessor the rent in arrear, together with interest thereon and his full costs of the suit, or gives such security as the court thinks sufficient for making such payment within 15 days, the court may, in lieu of making a decree for ejectment, pass an order relieving the lessee against the forfeiture, and thereupon the lessee shall hold the property lease as if the forfeiture had not occurred. 114A, relief against forfeiture in certain other cases. where a lease of immovable property had determined by forfeiture for a breach of an express condition which provides that an breach thereof the leaser may re-enter, not suit for ejectment shall lie unless and until the leaser has served on the leasee a notice in writing. A. Specifying the particular breach complained uh, specifying the particular breach complained of, and B, if the breach is capable of remedy, requiring the lessee to remedy the breach, and the lessee fails within a reasonable time from the date of the service of the notice to remedy the breach if it is capable of remedy, and the lessee fails within a reasonable time from the date of the service of the notice to remedy the breach if it is capable of remedy. Nothing in this section shall apply to an express condition against the assigning, underletting, parting with the possession or disposing of the property leased, or to an express condition relating to forfeiture in case of non-payment of rent. 115. Effect of surrender or forfeiture on under leased. The surrender, express or implied, of a lease of immovable property does not prejudice an under lease of the property or any part thereof previously granted by the lessee on terms and conditions substantially the same, except as regards the amount of rent as those of the original lease, but unless the surrender is made for the purpose of obtaining a new lease, the rent payable by and the contracts binding on the under lessee shall be respectively payable to and enforceable by the lessor. And the forfeiture of such a lease annuls all such under leases except where such forfeiture has been procured by the lessor in fraud of the under lessees, or relief against the forfeiture is granted under section 114. 116. Effect of holding over. If a lessee or under lessee of property remains in possession thereof after the determination of the lease granted to the lessee, and the lessor or his legal representative accepts rent from the lessee or under lessee, or otherwise assents to his continuing in possession, the lease is, in the absence of an agreement to the contrary, renewed from year to year or from month to month, according to the purpose for which the property is leased, as specified in section 106. Illustrations. A lets a house to B for 5 years. B underlets the house to C at a monthly rent of Rs 100. The 5 years expires, but C continues in possession of the house and pays the rent to A. C's lease is renewed from month to month. B. A lets a farm to B for the life of C. C dies, but B continues in possession with A's assent. B's lease is renewed from year to year. 117. Exemption of leases for agricultural purposes. None of the provisions of this chapter apply to leases for agricultural purposes except insofar as the state government may by notification publish in the official gazette declare all or any of such provisions to be so applicable. In the case of all or any such leases, together with or subject to those of the local law, if any, for the time being in force, such notifications shall not take effect until the expiry of 6 months from the date of its publication. Chapter 6 of expenses when we come back. Chapter 6 of expenses when we come back.